is Rita Riccardi, Director of Retirement Plans for Fiduciary Pension Partners. Welcome to our webinar entitled The Latest Update on Secure Act 2.0. At Fiduciary Pension Partners, we are a full-service pension consulting firm. We offer fiduciary support, fee benchmarking, investment analysis, target date fund consulting, and plan design assessments to enhance participant retirement outcomes. We also offer access to our YouTube channel, Fiduciary Pension Partners. Please check it out for additional webinars that we hold. Today's webinar is being presented by Steve Puckett, Managing Partner at Fiduciary Pension Partners, along with our partner, Ruben Gonzalez from Janus Henderson Investors. Steve is the Managing Partner for Fiduciary Pension Partners and has over 30 years of experience in the retirement plans industry. Steve has assisted with and consulted on hundreds of companies with their retirement plan concerns and has been named as one of the top retirement advisors by the Financial Times for the past 6 years. Ruben is the retirement director for the Northeast for the Defined Contribution and Wealth Services team at Janus Henderson Investors. Ruben provides thoughtful advice and consultation regarding some of today's most complex retirement issues. We are thrilled to have Ruben join us, and now I'd like to turn it over to Ruben and Steve.
Thank you, Rita.
All right, thank you for that, Rita and Steve. Pleasure to be here, everyone. And as Rita mentioned, a couple of things, couple of housekeeping items. The main one. Today's session counts as 1 credit hour for CE. So if you hold a SHRM designation, HRCI, SPHR, or anything like that, please let Rita and Steve know. Happy to process your CE today, and we'll make sure you get it in a couple of days. Also, for those of you who hold the CPA designation, today's session also counts for 1 credit hour CPE credit for you as well. So again, just please let Rita and Steve know, and we'll go ahead and get that out to you. Okay, so we'll just begin with the Secure Act 2.0. As many of us know, it was enacted very late last year. It's part of that $1.7 trillion Omnibus or Consolidated Appropriation Act, and it includes 92 separate provisions. Now, we're certainly not going to go through all 92 today. Just the more important ones are the ones that folks have the most questions about. And so we'll start there. Steve?
Yes, and most importantly, there have been a tremendous amount of questions, concerns with regard to this. Obviously, this is a large, over 2,000-page bill, so we have been seeing a lot of separate questions on taxation, on impacts of the way the bill works, and payroll, taxation, and retirement planning. So certainly, we want to give you the latest. Because everything does change, and certainly, this is a big bill and a big step for all of our plan sponsor clients. The other thing that I want to make sure you understand is, obviously, you need to have a conversation with your service provider, whether it's Fidelity, Empower, Lincoln, whomever your service provider is. Many of them have undertaken systems upgrades to allow for some parts of this bill. Others are only working on the mandatory parts of the bills and waiting for the optional parts. But certainly you need to have a conversation with your service provider. And more importantly, many of these provisions are going to be in an opt-out or an opt-in provision. So the service provider is going to automatically amend their plan documents. But if you don't want some of these provisions, you're actually going to have to opt out. If you do want some of these provisions, you're going to have to opt in. So some of these provisions will be in their standard amendments. Others, the service providers have chosen not to include. So if there is anything that you want, again, you're going to want to make sure provision by provision. So you're going to want to look at it. Secondly, this needs to start a conversation with your retirement committee, your executive management. Again, there's mandatory provisions that must happen. Now, again, you're probably just going to, follow those mandatory guidance. But the optional provisions may be appropriate for your organization, might not be appropriate for your organization. So you definitely need to have a conversation. This is either a committee discussion or an executive management discussion, depending upon the size of your organization and how your management and administration of your retirement plan work. So again, it is now time to have the discussion. And again, like Rita mentioned, for everyone on the call, we will offer a complimentary 30-minute review of the Secure Act and how it impacts your plan. Again, we'd be more than happy to offer that. Again, all you need to do is reach out to us after this presentation. Thank you.
Okay, thanks, Steve. So we'll jump right into some of the provisions. So as we all have heard by now, mandatory automatic enrollment and escalation. So any employer who starts a 401k or 403b after Secure 2.0's enactment are required, this is mandatory, right, to automatically enroll eligible employees into the firm's plan at a savings rate of 3% beginning after 2024. Okay, of course, employees have the ability to opt out or change their savings rate at any time. Also, we have auto escalation. So enrolled employee contribution rates are automatically increased each year by 1% until their contribution rate hits 10%, but no more than 15%. I think that's important to note. There are exceptions for everything, and certainly this provision is no different. So any business with less than 10 employees or open for less than 3 years are exempt, as are retirement plans for churches and governments.
Yes, and again, I want to offer the Main Street, what our clients are seeing on this. I think this, there's two things that come out of this. One is existing clients are now saying, hey, maybe we should offer auto enroll. If the Department of Labor, if Treasury is forcing this upon new 401k providers, maybe it's something that we should look into. So we are seeing a lot of our clients that never had auto enroll are now offering auto enroll or looking at auto enroll. Auto increase, the auto escalation. Again, it's forced upon us. So a lot of our existing clients are saying, well, we never had it. Is that something we should look at? If the DOL and Treasury thinks that this is something that must be in a retirement plan, maybe it's something that we should look at. So we are seeing a lot of our clients with the renewed interest. Obviously, that cap of 10%. Most companies that actually had auto increase in the past, maybe their cap was at 5% or 6%. So a lot of them are changing. Again, now is a great time to amend your plan document. There's a lot of things going on. So this might be something that you may want to include in that amendment. Let's just change our cap. The other thing that this is leading to is, eligibility tracking and online enrollment. Again, you need to have your plan automated. If you are forced to do automatic enrollment, that means you have to track eligibility. And again, would you rather track eligibility or would you rather have the service provider track eligibility? Many organizations are saying, I would rather have the service provider track eligibility. Well, again, if you want them to track it, then that means you have to use eligibility tracking. You have to get them all new hires. You got to get them a file feed. So this is going to lead to automating your plan. The days of paper and filling it out and faxing it in are going away. Again, in order to do this, the automatic enrollment, 3% automatic escalation, you want to automate your plan. And again, a lot of organizations look at automation and they think that they're going to lose control. They think there's going to be increased errors. The answer is yes and no. Again, if you use automation and do it right, plan it, prepare for it, again, you'll find that the amount of time, energy spent babysitting the small stuff will shrink. So absolutely. And again, the employees will always be able to opt out of the automatic enrollment and the auto escalation. But again, this is what the government is basically saying is best practices. And again, forcing it upon you. We do think that there's going to be a lot of organizations in that 20, 30, 40 life group that are going to be shocked and surprised of this. And so now is the time to get in front of this and certainly let them know as well.
Hey, Steve, a quick question for you. Since many plan sponsors match at the 3% level. Do you find there's any apprehension with plan sponsors, auto enrolling folks at that 3% level?
Yeah, so I think, the auto enrollment level traditionally has been 2 or 3%. We are now starting to see more organizations use 4, 5, 6% as the automatic enrollment number. The automatic increase, typically we see that cap. That cap traditionally is set at where the match is maxed out. So they may do a 3% automatic enrollment, but they might do a cap at 6% because the match is 50% up to 6. But again, what this is showing us is you don't have to limit that. Again, you must use 10% as that new cap on new companies. So many organizations are starting to do that as well. So again, studies show that, again, if you are looking to do right by your employees and get them to a successful retirement, nothing works better than automatic enrollment and auto escalation. The take rate is 90%. The opt-out rate is about 10%. So if you really want your employees to get to a successful retirement, this is the best thing you can do for them.
Thank you. Okay, our next provision, I would imagine does not apply to many on the phone, but we should all be aware of it, right? So for starter 401k plans, any employees that do not offer a retirement plan currently may offer a starter 401k plan beginning next year, 2024. All employees will be automatically enrolled at that in the plan at that magic 3%, up to, with auto escalation, a maximum of 15% of compensation. Interesting to note, a 403b version will debut next year as well. Also, annual deferrals into a starter 401k plan will sort of look like the match for IRA contribution limits, which is currently $6,500 with an additional $1,000 catch-up contribution. Interesting to note that $1,000 catch-up contribution will be indexed for inflation on a go-forward basis.
Yeah, and the starter 401ks obviously doesn't impact organizations that have a retirement plan. There is a lot of questions about how this would work. In theory, this would be more like a payroll deduct IRA. Obviously, the IRA limits apply, not the 401k limits, so it would be a much lower limit, but there potentially may be no compliance testing. So there may not be any of that ADP test, ACP test, or top-heavy test. So this may, for some smaller organizations, might work well. And specifically, those would be organizations that tend to fail those compliance testing. Doctors, dentists, lawyers, small practices where they tend to get top heavy or they tend to fail because of deferral rates.
Next up, we have emergency savings accounts, new, right, for all of us, or yeah, pretty much all of us. So employers now have the option to amend their plan and offer non-highly compensated employees, I underline that just to be clear about it, an emergency savings account together with the 401k plan. Now, employee contributions are made on a Roth basis, right, so after tax, and is capped at a maximum of $2,500. The key here is that those assets, unlike, say, an HSA where you can put money in and you invest it in an index fund, for example, that's not the case here. You can only invest that emergency savings account money in an interest-bearing account. So think money market along those lines. Distributions are tax-free, important to note, and employers can automatically enroll employees into these accounts at no more than 3% of salary. Employee contributions, remember, are an elective deferral, right? So if a company offers a 401k match, contributions into the ESA are eligible for a company match. Also important to note, matching contributions are not made into the emergency savings account. The match is made into the participant's 401k account.
Yes, so the view from Main Street on this is very, very excited. I think there's a lot of organizations that see their employees and see that, their employees could not afford a $500 or $1,000 emergency, a car accident, a medical bill. There's a lot of union employees, a lot of lower paid employees where, again, an emergency, an issue would harm them financially. They would have to put it on a high interest credit card or a payday loan. So there is a tremendous amount of interest in this. And specifically, in those cases where, low paid employees, union, again, lower paid organizations or high turnover organizations. Again, the questions we get here, obviously, is it is for only non-highly compensated. So it's not for highly compensated, it would just be non-highly compensated. Those employees could opt out. Just like everything else, they could opt out. There would be a cap. So once the employee hit that cap, in essence, their contribution would turn off. And kind of the other thing with kind of that cap, a lot of service providers are trying to create an option. None at this point have an emergency savings account option. I know Fidelity has been pushing to try to get this thing up and running by the end of the year. It doesn't look like it will be available. But the idea would be if you cap that 2,500, maybe they could spill over that 3% and just put it into your 401k. But again, the systems need to be programmed that way. And again, with you could imagine these massive computer systems, it's just not as easy as flipping a switch. They actually have to create this emergency budget. Yes, that's it. And again, the other question we have is, that $2,500, is that per year? No, that's capped for the account. So that emergency savings account cap would be $2,500. You could access that money once per month, tax-free. So again, if you had an emergency, you could pull out $1,000. If your $2,500 went down to $1,500, again, your 3% would in essence turn back on until you hit that cap of $2,500. Once you hit that $2,500, again, you would not have any more monies pulled out of your account. But that is a lifetime in this emergency savings account. And again, like I mentioned, the providers would love it where you start with these emergency budget accounts, and then that would automatically spill over into retirement savings. Have that 3% go into your traditional 401k or 403b account. Systems aren't there yet, but certainly we are hearing a lot of interest in the emergency savings accounts.
Next up, we have a second tier of catch-up contributions for everyone. So the new thing with Roth 2.0 is employees who are 60, 61, 62, and 63, and only those folks, can contribute a catch-up contribution in the amount of $10,000 in 2024, or 150% of the regular catch-up amount starting in 2025 into a 401k or a 403b. And just to reiterate, the existing catch-up provisions for folks 50 and over, no change there. The catch-up contributions would be subject to cost of living adjustments on a go-forward basis, right? And also, and I know this generated a lot of questions, certainly earlier on in the year. You will recall that for highly compensated employees, folks who made over $145,000, their catch-up would have to be done on a Roth basis. The challenge there, to Steve's earlier point, the record-keeping companies like Empower, Fidelity, they just weren't ready. They didn't have the mechanisms in place. So as a result, the IRS issued a guidance August 25th of this year, so relatively recently, that we have a 2-year delay in that provision's effective date, which mandates those catch-up contributions have to be in Roth. So catch-up contributions can now, for highly compensated folks, be made on a pre-tax basis through 2025, regardless of one's income. The other thing that I think is important to note, you may have heard that there was a technical error in Secure 2.0 that would have eliminated all catch-up contributions beginning next year in 2024. That technical error was corrected, so moving forward, we don't have to worry about this particular error. See.
So the good news is we have a 2-year reprieve on this very difficult, very concerning Roth catch-up for some highly compensated employees. So again, the good news is 2024 business as usual. 2025, we now then enter, this age 60, 61, 62, 63 piece, which is again, that will be a difficult one to administer, obviously a difficult one to, to communicate to your employees. But again, the good news is this has been pushed back. So the biggest problem we had in the last 6 months is getting pushed back. My big concern, I am no longer talking about Main Street and plan sponsors. I'm talking about the government. This part of Secure Act 2.0, the Rothification, forcing people to put their money in Roth, that paid for the preponderance of this bill. So this basically paid for all of the other freebies that they're giving away. This 2-year delay obviously is going to impact this feasibility of the bill. How that impacts, who knows, whether they may pull some parts of it out or not. But it is concerning to me that this bill was being paid because of these two catch-up components that now have a 2-year window on. So more to be found out from there. But at this point, it's good news, but we will find out more about how this impacts every other component of this bill.
Next up, we have a whole flurry of distribution changes as a result of Secure 2.0. We have new emergency withdrawals that's limited to $1,000 per year and will be available to employees starting next year. Important to note, distributions must be repaid within 3 years, and no further emergency distributions are available while that participant is repaying that money back. Just out of curiosity, what's an emergency personal expense? According to the government, unforeseeable or immediate financial needs relating to necessary personal or family emergency expenses. It's broadly defined for a reason, I would imagine. Also, we have qualified long-term care distributions. For those of us who want to pay our long-term care premiums using our 401k money, you can certainly do that up to a maximum of $2,500 per year. That goes into effect 3 years from the effective date of Secure 2.0, which remember was December of last year. Also, for domestic abuse survivors, they can withdraw the lesser of $10,000 or 50% of their account balance. Individuals who are affected by a federally declared disaster can withdraw up to $22,000. And again, all of these distributions are exempt from a 10% early distribution tax.
Thank you, Ruben. So this is the Pandora's box of withdrawals. And first and foremost, many service providers are automatically including some of these in their amendments. So for instance, if they automatically include the long-term distributions and you did not want that, well, then you would have to opt out of it. Others, they are not including, maybe in their amendment, they are not including the domestic abuse survivor provision. If you would want that, then you would have to opt in and notify them that you are wanting in on this. So again, these are the opt-in, opt-out based on what they are going to be doing. The big issue here is obviously leakage. Like Ruben mentioned, you pretty much, anybody could take their money out and create any foreseeable expense needs. Again, the qualified long-term care, again, does that make sense? The people that have long-term care typically are your executives or highly compensated. So again, are you discriminating in favor of them? The domestic abuse provision, we have not figured out. We have looked at PLRs. Is it from the event? Is it does it from a medical professional needs to notify? Is it legal? What constitutes domestic abuse? That's a big one. The federal disaster area, at least we know the federally disaster, they announced that, obviously Hawaii. But again, if you look at the amount of that is a large distribution. So what we tend to see is the bulk of our plan sponsors are saying no, 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 no. Because again, if you have a loan provision, you may have the hardship provision as well. Again, this is just more ways of the people who shouldn't be taking their money out, taking their money out. Because what you will find is the people that will use these very broad-based expenses are the ones that are getting the second, third, fourth loan. They're the ones that are, basically getting their money out of their retirement so that they can go down to Atlantic City or buy a boat or remodel the kitchen or buy the brand new car. So a lot of our clients are basically saying no on all of these.
Oops. Next up, we have the expedition of part-time work.
Student loan. You missed the student loan.
Oh, no,
no.
I skipped ahead.
Oh, it's next. Okay, there we go.
Mhm.
Sorry about that, Ruben.
No, they're good. So expedite part-time worker participation. So as we know, in 2019, Secure Act, the original Secure Act, allowed long-term part-time employees who worked at least 500 hours for 3 consecutive years to contribute to the 401k plan. Well, Secure 2.0 reduces that 3-year rule to 2 years for plan years beginning after December 31st of 2024. So again, note that the 3-year rule applies to plan years beginning in 2024, and a new 2-year rule will apply for plan years beginning in 2025.
Yes. So before we move off on this, so the confusion here, obviously, we have this 3-year window that begins plan years after 2024. We have the 2-year window. What we're starting to see more organizations do is just allow your part-time employees to participate in the plan. Again, if you just allow them to participate in the plan, then you no longer really need to check hours and check to see whether they meet this 500-hour limit for 3 consecutive years. If you just allow them in the plan, administratively, it's less. Now, again, you can allow them in the plan and not allow them to have employer monies. But if you just allow them in the plan, then you no longer have to track hours. Otherwise, if you absolutely do not want them in the plan, you may want to start thinking about how you're going to track hours for those organizations that have hourly employees or have seasonal employees or have consultants or 1099, anybody. You may want to come up with a game plan there. But the one structure, the one provision that we do see a lot more organizations are just saying, we will allow them in our plan. We will not match them until they hit 1,000 hours, but we'll just allow them in the plan.
Student loan payments with employer match. So this is probably one of the more interesting ones in the act. So this legislation allows employers to make a matching contribution to an employee's retirement account based on the employee's student loan payments beginning in 2024. And matching contributions for student loan payments must vest as using the same schedule as other matching contributions. And what's a qualified student loan payment? Well, that's defined as any indebtedness incurred by the employee solely to pay for higher education expenses.
Yes. So like Ruben mentioned, this is a very hot topic. And specifically with corporations that recruit and hire college grads. We see, the average college grad can come out with $80,000 to $100,000 to $150,000 of student debt. So again, we have a lot of organizations that like the idea of using this as a kind of a hiring tool. This can be in their new hire package. This can be in kind of their marketing package that, oh, by the way, unlike other organizations, we will match you in your 401k on any student loan payments that you make. So that's great. The downside here, it's not ready. No service provider has built this program yet. Currently, it's been under a private letter ruling. Again, so organizations are trying to figure out how to make this thing work. Again, verification of student loans. Is that an HR responsibility? Is that a self-certification responsibility? Again, it just more administration for an overworked HR team. Also, is it fair? Again, if you have older organizations, middle managers, 40 years old, 45, that had to pay their student debt, didn't get matched on it, how equitable, how fair is it where now all of a sudden you're going to do this? We do see it both ways. It is not ready currently. My guess is there are some organizations, some service providers that are very keen and want to get this thing launched as soon as possible. I would venture to guess at the earliest it will be middle of 2024, but certainly we are seeing interest in this, and specifically if you do hire, those college grads, it could be a great marketing tool, because I imagine there's going to be a lot of organizations that will not use this tool. And again, you just have to make sure your 401k has a match, because again, it's going to follow the match formula under your 401k plan. I've had clients that say, well, can we have a different match for this than our regular match? Or, can we somehow do a tier, a student loan match versus a real match? No, again, how you're going to want to do this, it's going to mirror your current match.
All right, modification of the small business 3-year startup credit. So yeah, again, I don't think this is going to apply to many of you or most of you, but Secure 2.0 increases the startup 401k credit from 50% to 100%, up to an annual cap of $5,000 for any employer with up to 50 employees starting this year. For employees with up to 50 employees, the startup credit is increased by employer contributions, right, by $1,000 max per employee. And this provision gets phased out once you start to hit between 51 and 100 employees. The credit percentage is 100% for year 1 and year 2 of the plan. Year 3, 75%. Year 4, 50%. Year 5, 25%, and then nothing thereafter. The goal, obviously, here is to incentivize small businesses to implement a retirement plan on a fully or almost subsidized basis.
Yeah, and again, going back to how we're paying for this, this is a big bill. Obviously, they're giving a startup credit up to $5,000 per employer. So again, just great news for organizations needing to start a plan. Again, the government and many of the states are forcing these small business owners to start up a retirement account. So this is basically just giving them an incentive. Good news all around. Again, the other thing is a lot of those small business owners never file the credit. So again, it's great that you have this, but if you don't file the credit, you don't get the credit. You have to make sure you file the proper IRS forms.
Okay, required minimum distribution reform. So we know that the age start taking RMDs went up to age 73 in 2023, and it goes up to age 75 in 10 years, so 2033. What's interesting to me is that it reduces that 50% excise tax that's been around forever on, for example, missing a required minimum distribution payment. It reduces it down to 25% and 10% if the mistake is corrected in quote unquote a timely manner. Now, to the extent of an RMD shortfall, right, or an excess contribution, I over contribute to my IRA, for example, that statute of limitations for assessing penalties will generally be tied to when I file my Form 1040. And just so you know, the RMD penalty statute is 3 years if I forget to apply for my RMD, and 6 years if I over contribute to my IRA, for example. So plenty of latitude in regards to making amends with the government and reducing my penalty.
Yes, so this is obviously good news. They wanted to throw this in after the Secure Act 1.0 got rid of the stretch IRA. Again, in the old days prior to Secure 1.0, you could, if you inherited an IRA from a parent, you could stretch it out over your lifetime. That is now 10 years when you need to take that money out. So that was a big hit, obviously a tax revenue generator. This is kind of a gift to quell that, where you now can go as far as 75 before you need to take out a required minimum distribution.
Also, we have distributions from 529 accounts to Roth IRAs. So 529 beneficiaries, right, may make tax and penalty free rollovers from their 529 savings account to a Roth IRA starting next year in 2024. So those rollovers can amount to a maximum of $35,000 over the course of a beneficiary's lifetime. Also, rollovers are subject to Roth IRA annual contribution limits for that particular year. Oh, I'm sorry, I'm getting feedback. Okay. 529 accounts must have been open for more than 15 years before any transfer is allowed. So the question that we have, or that I had, was, well, if I start a 529 for my son, and then in year 14 sign that account over to my daughter, does that 15-year time clock start again? We don't have clarity on that. And it's also important to note that IRA owners must have earnings or compensation at least equal to the amount of that particular rollover as well.
Yes, and this is, one of the non-retirement provisions that I am very excited about. Being a parent of 3 children and having 529 accounts, I think this is a fantastic opportunity. Again, being able to take that money out of a 529 plan and move it into a Roth IRA for your child. Excellent. Again, non-taxable events. Again, you can move up to $35,000 over the lifetime. What Ruben mentioned about the 15 years before transfers. Again, the 529 plans were created in 2001. They were part of the Economic Growth and Tax Reconciliation Relief Act. But it was state by state. So each state created their own 529 plan. And each of the record keeping capabilities of each of those states, some are robust, some are very poor at best. So many times if you move from one state to another state, they restart your clock. They don't give you that original start date. So again, the point of if I change the beneficiary, well, even if I change states, I might lose that 15-year notice. So what we've talked to Treasury and Brian Graff over at the American Retirement Association, I think this is going to be a self-certification piece, that the record keeping from the states, whether it's New York, whether it's Arizona, whether it's California, is so poor at tracking when these were opened, when the beneficiary was selected. And again, if you've ever changed states, maintaining that original start date. So I think this will be a self-certification. But again, the good news is you could move $35,000 into that child's account. Again, it's the beneficiary, it's not the owner. They just need to have income. So again, the limit would be that the Roth IRA limit, $6,500 currently. So they would have to have $6,500 of compensation so that you could then move that over. And again, 6 years, 7 years, you could do a lifetime of $35,000.
We also have some increased and enhanced qualified charitable distributions. Now, admittedly, this is probably for your highly compensated employees. So we have the maximum qualified charitable distribution of $100,000. That's going to be indexed for inflation. It started last year. And also we have a one-time transfer, and this is brand new, of up to $50,000 from an IRA into what's called a split interest entity. So think a trust, right? Specifically a charitable remainder trust or a charitable gift annuity trust. Now, we call them CRUTs and CRATs. They can only be funded with a qualified charitable distribution. It's the only way to get money into those trusts. And they can only benefit the owner and or their spouse, and that's effective immediately, but relatively expensive to set up those trusts.
Yes, and we are starting to, again, the CRUTs and the CRATs and the annuities, these are insurance agent driven. So the insurance agents have heard this and said, wow, great, $50,000, $100,000. They're going to their clients and saying, hey, contact your HR manager and tell them you want a $50,000 charitable remainder distribution. That's not as easy as it happens. The insurance agents love that and they think that's how it's going to work. The plan actually has to allow it. You're going to have to amend the plan document to allow this. But it has created a lot of confusion because obviously those, typically your, mid-managers, 40 to 60-year-old, maybe working with an insurance agent, and the insurance agent gets in their head and saying, get this. And obviously, your key employee, he may be, a great employee. He wants this. And obviously you don't want to tell him no. But again, if you do hear this, charitable remainder trust, charitable gift trust, it's not right now. And again, the plan document would have to be amended for it. So just be aware that it is there. But again, don't feel like you need to, somehow rework your plan for that one individual.
Wise words, Steve. Up next, we have Roth retirement plan account required minimum distributions. So Secure 2.0, as we know, exempts, or you may know, exempts Roth accounts in employer retirement plans from RMDs starting in 2024. As we know, Roth IRAs are not subject to RMDs while the owner is alive. Both Roth IRAs and retirement plan accounts are still subject to post-death RMDs, and all the funds must be distributed within 10 years following the death of the beneficiary account holder. So again, I just want to make mention of this. If someone who's turning 73 years old in 2023, their Roth account RMD must still be made by April 1st of 2024.
Yeah, and my only point is they're just putting 401ks and IRAs on equal playing field. So this is more of a non-event, again, mandatory, nothing you need to do. All the service providers will automatically put this in your document. You will automatically be assumed that this is going to happen because it is mandatory.
And our final slide here, this is sort of the potpourri of provisions. So we'll start off with ABLE accounts. ABLE accounts are double tax advantage savings programs for people with disabilities. So things people with Down syndrome, autism, maybe it's a motorcycle or a car accident. Okay. Now, not every state has an ABLE account. So, but you are free if you live in a state that does not have an ABLE account. You can participate in another state's ABLE account program. Distributions from an ABLE account are tax-free if used for qualified disability expenses for that account beneficiary. Also important to note that you can have a maximum of $100,000 in ABLE account, and that $100,000 does not impact any benefits that that disabled person may be receiving from the government. The key here is $100,000. You go over $100,000, that changes things. So effective from in 2026, ABLE accounts can be established for folks with a disability that's occurred before age 46. Currently, the age is 26. So the goal here, obviously, is to capture more people with disabilities up to 46. Also, we have QLACs, qualified longevity annuity contracts. They can begin payment. Usually what ends up happening is people who are at 65 or 70 decide, I'm a little fearful of outliving my savings, so they buy these annuities so they don't run out of money in their very golden years. That purchase amount has increased to $200,000. That $200,000 number is indexed for inflation, and the 25% of account balance limitation has been repealed as well. And lastly, we have the 72T, or it's also known as substantially equal life expectancy periodic payments. That's a mouthful. That will continue to be exempt from the 10% additional tax, including in the case of a partial rollover or transfer account. So the new thing here is that if you take these equal payments, instead of taking it from one account, you can now take it from two. So I can take it from my 401k and my IRA at the same time. So that's a big upgrade from previous rules.
Yeah, and just a couple of quick points. You know, the ABLE programs are separate from your qualified plan. It is state sponsored and it has nothing to do with your plan, but be aware of the name. You may get employees that ask about them. QLACs, again, everything that I mentioned about the previous annuities, the cruts and the cracks are the exact same here. You will find insurance agents will reach out to your employees and say, hey, I want to do a QLAC. Again, these are mostly out of IRAs, but it could be in your defined contribution plan. But again, you're going to have to amend the plan to allow a QLAC out of your plan. So most defined contribution plan documents do not allow insurance in the plan. And so again, we'll see how this is, but you may get an employee that says, hey, I would like a $200,000 QLAC out of my 401k plan. You can tell them it is not currently allowed in our plan document. It is something that we will review and we will let you know if that is something we go through. Again, you definitely want to word it that you want to do research on it, but you do not have to allow it. So, but be aware of that term because you may get employees that ask you about the QLAC. And then the sub-D2T, again, nothing that I think impacts, the HR, CFO teams that we work with. It is more a matter of point as well.
Okay, and that is it.
Fantastic. Well, and again, thank you very much, everyone, for joining us. Again, just to recap, most importantly, this must start a conversation with your service provider. You need to talk about how they are going to be amending their documents. Many of these provisions will be already incorporated, and you will need to opt out if you do not want them. And others won't be incorporated, and you're going to need to tell them that you want into that. Again, it's also a conversation with your committee members, a conversation with your executive committee. Again, the big ones that we get a lot of questions: the Emergency Savings Act and the student loan. They're not available currently. Record keepers, again, have been worried about all the mandatory provisions. So the voluntary have not been looked at yet, but it is something that you should plan on. Again, I think for most of our organizations, typically it's either one or the other. The emergency budget, again, that's great for employees that just have not been able to save that $2,500 for an emergency. And again, they could opt out of it, but 90% of them won't, and at least they could access their money once per month. Again, even if they use it as a revolving Christmas account, it would still be great. The student loan, again, I think, the equity of that, the fairness of it, but it could be a great marketing tool as a recruiting tool. So those are the ones that we are getting the most questions for. But again, it is a conversation that you want to have. And certainly we offer a complimentary 30-minute review, Secure Act, your organization. If that's something that you would like to sit down with us, we'd be more than happy to offer that. With that, I will turn it over to Rita to close. Thank you very much for your time. We appreciate it.
Yes, thank you, Ruben and Steve, so much for your thoughtful insights on all these provisions. As you know, they're changing, and we certainly will keep everyone abreast of that. As Steve mentioned, we'll be offering a 30-minute consultation on the Secure Act 2.0 provision if you're interested. We will also be sending frequently asked questions sheet on the Secure Act to all attendees. And if you are interested, as Ruben mentioned, on CE credit, please reach out to us at info@fiduciarypp.com, and we will get that off to you. Thank you all so much for your time. Wishing you all a great day. Be well.